There is a sentence in your lease, in every residential lease in America, that your landlord did not write, that you did not negotiate, and that they cannot remove no matter what the rest of the agreement says. It gives you the legal right to walk out of that lease early, return your keys, and owe nothing for the remaining months. Not a reduced amount, nothing. And the move that triggers it costs one stamp and about 20 minutes of your time. Most tenants never use it, not because it doesn't apply to them, because nobody told them it exists. My name is Paul Mercer. I practiced consumer protection law for 30 years, tenant defense, legal aid, insurance bad faith, mortgage closings, always on the people's side of the table. I'm retired now, and I spend my time explaining exactly the kind of thing I used to charge $300 an hour to explain. What I'm sharing today is general legal information based on that experience. It is not legal advice for your specific situation. Laws vary by state, and for something this consequential, if your situation involves active eviction proceedings, personal injury, or a rent-controlled unit, you need a licensed attorney in your jurisdiction, not a YouTube video. That said, the principle I'm about to walk you through applies in all 50 states, and I will tell you where to check for your state's specific version. Now, let's talk about what your landlord is counting on. The standard residential lease is built around an assumption that you will pay rent no matter what happens to the unit, because the penalty for leaving early is severe enough to keep you locked in. In most markets, that early termination fee is 2 to 4 months' rent. At the national median of $1,379 a month per ApartmentList, May 2025, that's between $2,750 and $5,500. Gone the moment you hand back the keys without the right legal footing. That number is your landlord's leverage. And it works. Most tenants faced with substandard conditions, broken systems, uninhabitable heat, or black mold calculate the penalty and decide it's cheaper to stay. They don't know there's a second path, one that costs nothing. The law that eliminates that penalty has existed since 1970. It's been upheld in every state. It's been codified in more than 20 states' statutes, and it has been systematically absent from the conversation landlords have with their tenants about what their rights actually are. The law is public. The case law is on the books. The statutes are searchable. But the business of renting housing works better when tenants don't push back, and the most reliable way to prevent pushback is to make sure tenants don't know the law gives them the power to. That's not a conspiracy. It's a documented pattern. I'll show you the evidence in a moment. First, let me tell you how we got here. In 1970, a group of tenants in a Washington, D.C. apartment building called Clifton Terrace refused to pay rent. When their landlord, First National Realty Corp., took them to court for eviction, those tenants showed up with bags of mouse feces, dead roaches, and a housing inspector who testified to over 1,500 documented code violations in the building. 1,500. The lower court ruled all of that evidence inadmissible. It said, "The condition of the building is not relevant to whether the rent is owed." The landlord still wins. A federal appeals court reversed that decision. The case is Javins versus First National Realty Corporation, 428 F. 2nd 1071, D.C. Circuit, decided May 7, 1970. The court said the old rule, which went back to medieval feudal property law, a doctrine called caveat lessee, meaning let the renter beware, had no place in modern American housing. A lease is not just a land transfer. It is a contract for a service, the service of providing a livable home. And if the landlord isn't delivering the service, the obligation to pay runs out. The landlord in that case, by the way, was separately jailed for heating system violations while the appeal was being decided. The law has never been the same since. 2 years later, in 1972, the Uniform Law Commission drafted a model statute, the Uniform Residential Landlord and Tenant Act, or URLTA, that translated that ruling into written law state legislatures could adopt. The American Bar Association endorsed it. Today, 21 states have formally adopted versions of it, and every other state has absorbed at least its core principle through court decisions. The landlord's duty to keep a rental unit livable is not a favor. It is a codified legal obligation in every state in this country. Every state, not most states, every single one. Arkansas was the last holdout. They passed their version in 2021, Arkansas Code Section 18-17-502. So, wherever you're watching this from, the law in your state has this written in. The question is whether you know how to use it. Here's what the law actually says. In every residential lease, regardless of what that lease document says or doesn't say, the law writes in what lawyers call the implied warranty of habitability. It is implied, meaning it doesn't have to appear in the written lease. The law inserts it automatically. What it requires of your landlord is this: they must maintain the rental unit in a condition that is safe and fit for human habitation for the entire duration of your tenancy. Not just when you move in, not just when it's convenient, for the entire time you're paying rent. That means functional plumbing, heat, hot water, electrical systems that work, structural soundness, pest-free conditions, compliance with applicable housing codes. Landmark precedent: Javens versus First National Realty Corporation, 428 F. 2nd 1071, D.C. Circuit, 1970. Codified in California Civil Code Section 1941, Florida Statute Section 83.51, New York Real Property Law Section 235B, Oregon Statute Section 90.320, Arkansas Code Section 18-17-502. In URLTA states, the obligation is spelled out in Section 2.104 of that Act. In all 50 states, it exists either by statute or by controlling court decision. Now here's something that surprises most people. This warranty cannot be waived, not by the landlord, not by you. Even if you sign a lease that says tenant accepts unit in current condition and waives any claims related to the condition of the property, that clause is void. In New York, Real Property Law Section 235B says explicitly that any waiver of the warranty of habitability is void as contrary to public policy. The Uniform Residential Landlord and Tenant Act, Section 1.403, prohibits rental agreements that waive the landlord's maintenance obligations. Most states follow the same principle. You didn't give away this right when you signed. You couldn't have, even if you wanted to. And here's where the documented pattern comes in. In 2022, a Boise, Idaho nonprofit called Jesse Tree reviewed 40 residential leases from their area. 40% of those leases contained clauses that were questionable or outright illegal under Idaho state law. As is acceptance language purporting to waive repair rights. Security deposit terms that contradicted the statute. Some of those leases contained explicit language acknowledging that parts of the lease might be invalid and left those parts in anyway. A California tenant advocacy organization called Tenants Together documented the same pattern. Their communications director said, "Landlords often sneak unnecessary and invasive clauses into leases, expecting that the tenant either won't read the fine print before signing or won't feel empowered to negotiate predatory clauses out of the lease." They said it publicly. That's a documented business practice. The question is why landlords include clauses they know or should know won't hold up in court. The answer isn't complicated. If 1 in 10 tenants knows the clause is void and pushes back, the landlord loses that fight. If 9 in 10 assume whatever is in the lease is legal and enforceable, the landlord collects rent on substandard housing for the rest of that tenancy. The math works in the landlord's favor, as long as you don't know. Let me show you the counter move. There is one document in this entire process that makes the legal right real, that starts the clock, that creates the paper trail, that gives you everything you need if the case ever goes in front of a judge. And most tenants who know they have a right to leave still get this wrong. The document is the written habitability notice, the letter. This is not optional. This is not a courtesy. In virtually every state, the law requires that before you can exercise your right to terminate the lease based on habitability, before you can walk out penalty-free, you must give your landlord written notice of the problem and a reasonable window to fix it. If you skip this step, you may have broken the lease the standard way, and then the early termination fee applies. I wrote hundreds of these letters in 30 years of practice. Let me walk you through every element. The letter has 6 parts. First, the date, your name, your rental address, and the landlord's name and address. You need this to establish the record. When this letter was sent, who sent it, and to whom. Second, a factual description of the condition, not emotional, not argumentative, just the facts. As of date, the heating system in the unit located at address has been non-functional. The interior temperature has dropped to degrees on multiple occasions. I documented this on dates. Specific, dated, factual. If you have photos, say so. I have photographic documentation of the condition, dated, date. Third, the legal grounding. You are not threatening, you are informing. Under your state's habitability statute, the landlord is required to maintain the premises in a habitable condition throughout the lease term. Citing the law tells the landlord this is not a bluff from someone who doesn't know the rules. It tells any future judge that you knew your rights when you acted. To find your state's statute, search Your State Implied Warranty of Habitability Statute and look for the state government or law school legal aid source, not a blog. California, Civil Code Section 1941. Florida, Section 83.51. New York, Real Property Law Section 235-B. Oregon, Section 90.320. Fourth, the repair demand. Clear and specific. I am requesting that the heating system be repaired and restored to full function within time period. The time period depends on your state and the severity of the condition. In Florida, Section 83.60 sets a 7-day notice requirement for habitability issues. In most other states, the standard is reasonable time. Courts have interpreted that to mean the more serious the condition, the shorter the window. A burst pipe in January is not a 30-day fix. A non-functional heating system in winter, courts have found 24 to 72 hours to be reasonable in many jurisdictions. Fifth, the stated consequence. If the above condition is not remedied within time period, I will exercise my right under state statute to withhold rent, terminate the lease, or pursue other remedies available to me under state law. You are not making a threat. You are giving notice of what the law allows you to do. Most landlords who receive that sentence with a statute citation respond. The ones who don't have just handed you the paper trail you need. Before you state that you intend to terminate, know your state's specific path. Some states require depositing withheld rent into escrow, not simply not paying. Repair and deduct is allowed in many states, but not in Florida, where it requires landlord authorization. Check your state's procedure before you choose your remedy. Sixth, the delivery method. Certified mail, return receipt requested. Every time. Not a text message, not email, not a verbal conversation. Certified mail with a green card coming back to you with your landlord's signature and the date of delivery. That green card is evidence. In a contested case, that timestamp is the difference between winning and losing. Send a copy to yourself. Keep the original in a folder with your lease. Now let me tell you what this letter is not. This letter is not a magic trick. It works when the underlying condition is real, when the unit genuinely fails to meet habitability standards under your state's law. The warranty covers conditions that affect health or safety. It is not triggered by cosmetic problems or inconveniences. A broken closet rod is not a habitability violation. A noisy heater that still heats the unit is not a habitability violation. Paint that's chipped in one corner is not a habitability violation. The threshold is no functional heat in winter, no running water or hot water, severe mold or mildew affecting air quality, an established pest infestation, structural damage creating safety risk, non-functional plumbing. These are the conditions courts have recognized. If your problem is real and serious, and many tenants watching this are dealing with conditions that clearly cross that line, this right applies to you. But be honest with yourself about whether your situation clears that bar before you send the letter. One more thing before we talk about what happens next. There is a second protection in most leases that runs parallel to the warranty of habitability, and unlike the warranty, it's often written right there in your lease. Look for the phrase quiet enjoyment. What it means is that you have the right to use and enjoy your rental without substantial interference. Not just physical conditions, but conduct. Repeated unauthorized entry, utility shutoffs, threats, harassment. Courts in multiple states have found constructive eviction through landlord conduct alone, even without a physical condition failure. If your landlord is entering your unit without notice, cutting services, or making threats, the same legal framework applies. The written notice is still your first move. Now, I've seen too many tenants send this letter, watch the deadline pass with nothing done, and then sit there, not knowing what comes next. If you gave written notice, described the problem, cited the law, gave a reasonable repair window, and nothing happened, you are now at the threshold of what the law calls constructive eviction. This doctrine exists in all 50 states. It is recognized through common law in states that haven't codified it by statute. URLTA states have codified versions, and here is what it says. When a landlord's inaction, their deliberate failure to fix a condition they were put on written notice about, renders your unit substantially uninhabitable, the law treats them as having evicted you, even without a formal eviction notice. They forced you out. And if they effectively evicted you, your obligation to pay rent stops. The term is constructive eviction. It has 3 required elements. 1. A landlord breach that makes the unit substantially uninhabitable. 2. The tenant gave written notice and the landlord failed to remedy within a reasonable time. 3. The tenant actually vacated within a reasonable time after the landlord's failure. Hear that third element clearly. You must actually leave. You cannot claim constructive eviction and continue living in the unit. Courts in every state are consistent. If you stay, the legal argument weakens significantly. Once the repair window passes and nothing has been fixed, you leave, you document everything, and from the date of valid constructive eviction, you do not owe rent. Even if your departure isn't perfectly executed, in most states your landlord has a legal obligation to make reasonable efforts to re-rent the unit. They cannot simply leave the unit empty and send you a bill for every remaining month. New York codified this in Real Property Law Section 227E, enacted 2019. Most states impose the same duty through common law. Do it right, and you owe nothing. If something in the process isn't perfect, the landlord's mitigation duty limits the damage. Now let me do the math for you. The national median rent is $1,379 a month. If you break your lease the standard way, you are looking at an early termination fee of 2 to 4 months' rent, $2,758 on the low end, $4,137 on the high end. There is a documented example from New York City of a landlord seeking $15,000 for breaking a 1-year lease. The habitability-based termination route, $0 in early termination fees. Beyond that, when you exit through the habitability door correctly, your landlord is legally required to return your security deposit. Under New York Real Property Law Section 227, when a tenant validly vacates due to landlord habitability failure, the landlord must return all prepaid rent and security deposit. The URLTA framework at Section 4.206 mirrors this. If you are currently in a non-habitable unit and have already paid a security deposit, you may be entitled not just to leave with nothing owed, but to get money back. And in some states, the outcome can go further. California Civil Code Section 1940.2 provides that if a landlord engages in harassing conduct to force a tenant out, a court may award up to $2,000 per violation, plus actual damages, moving costs, and the value of the lost tenancy. Attorney fee shifting is possible in some states too. The free move can, in some cases, become a revenue move. Now, I want to be honest with you about when this doesn't work. The framework gives you significant power, but there are limits. First, this only works when the condition is genuinely major. Courts have dismissed constructive eviction claims over conditions the tenant found intolerable, but that didn't clear the habitability threshold. If a judge looks at your documented condition and sees a cosmetic issue, you lose, and then you owe the lease. Second, the procedure matters as much as the right. If you leave without sending written notice first, certified mail, documented, dated, you have triggered the standard early termination clause. The letter is the mechanism. Without it, you don't have the right activated. Third, state variation is real. The core protection exists in all 50 states, but what you can do with it varies. California Civil Code Section 11941 has been applied broadly by the courts here. Section 11940.2 adds harassment penalties. New York Real Property Law Section 235B explicitly voids any waiver of the warranty, and Section 227E requires re-rental efforts. Florida's statute is Section 83.51, with a 7-day notice period under Section 83.60, and Florida is one of the few states where repair and deduct requires landlord authorization in writing. Oregon's Section 90.320 provides explicit early termination rights when a landlord fails to maintain habitability, one of the more direct codifications in the country. Texas has the implied warranty, but remedies are more limited. Repair and deduct has specific procedural requirements under Texas Property Code Section 92.0561. In states with weaker protections, the right exists, but the enforcement tools are more limited. Check your state's official legislature website or your state bar's public tenant rights resources before you act. Fourth, there are 3 situations where you need a lawyer, not a YouTube video. First, if your landlord has already initiated eviction proceedings, do not navigate active eviction court without legal representation. Second, if the condition in your unit caused personal injury or illness to you or your family, that is a personal injury question requiring attorney evaluation. Third, if you are in a rent-stabilized, rent-controlled, or HUD-assisted unit, the rules are layered with additional federal and state law. Legal aid organizations in most cities handle landlord-tenant cases for free. Your state bar's website has a referral service. That's where to start. I've seen this work for tenants who thought they had no options. Let me tell you about one. Early in my practice, I had a client who was living in a second-floor apartment. In November, the boiler in the building failed. The landlord was informed verbally by multiple tenants. Nothing happened. 2 weeks passed. The temperature inside the units was dropping below 50 degrees. One tenant, on her own, typed a letter, sent it certified mail, described the condition, cited the state statute, and gave the landlord a 72-hour window to restore heat. The landlord's attorney called her within 48 hours. The boiler was repaired within the window. She didn't have to go anywhere. That is the most common outcome when this letter is sent correctly. Most landlords who receive a properly written habitability notice with a statute citation and a stated consequence respond, not because they suddenly care about your comfort, because they do know the law and the letter makes clear that you know it too. In the cases where the landlord doesn't respond, the tenants I represented had the paper trail to support a clean, legal exit and the return of their deposits. The leverage only works when the other side doesn't know the rules. They're counting on you not knowing. Now you know. Let me bring this back to where we started. The implied warranty of habitability in all 50 states says your landlord must maintain livable conditions for the entire lease term. You never negotiated for it. They can't remove it. A lease clause attempting to waive it is void. If the unit fails to meet that standard, your first move is the written notice. Certified mail. Dated. Specific. Statute cited. Consequence stated. The landlord gets a reasonable repair window. Florida, 7 days by statute. Most states, reasonable time based on severity, from 24 hours for emergency conditions to 30 days for less urgent issues. If they don't fix it, you are at the threshold of constructive eviction. You must actually vacate within a reasonable time after the window passes. From that point, you owe nothing. Security deposit returned. In some states, damage is recoverable. That's what knowing the law is worth. Before I close, I want to mention something for a specific group of viewers. If you are an active duty service member, there is one lease break right that is federal, universal in all 50 states, and non-negotiable. The Service Members Civil Relief Act, 50 U.S.C. Section 3901 and following. If you receive qualifying military orders, a permanent change of station, or a deployment of 90 days or more, you can terminate any residential lease with 30 days written notice. The lease ends 30 days after the next rent payment date following that notice. No fee, no penalty, no landlord discretion. If you're covered by the SCRA, use it. And for viewers who are past the "do I have to pay" question, who already left, or whose landlord's conditions caused real financial harm, there is a separate path. Small claims court handles most of the damages: moving expenses, temporary housing, security deposit, prepaid rent. In California, up to $2,000 per landlord harassment incident under Civil Code Section 1940.2, plus actual damages. That conversation belongs with a tenant rights attorney or legal aid, but the path exists. Wherever you're watching this from, have you ever found a clause in a lease that didn't look right to you? Something that seemed to take away a right you thought you had? Drop it in the comments. Tell me the clause and your state. I read every one, and I'll tell you what I see. You have more power here than they want you to think. The fine print was written to confuse you. Now you can read it. See you next time.